for business competitive because we believe that business is the backbone for every country, for every nation. Without business, without export import, without developing innovative products, it is very difficult to sustain in this world. So looking into that, uh, what is IPR exactly? So let us discuss. IPR is going to protect your ideas, your inventions, your brands, your works, your designs, uh, for a better business competitiveness that can enhance your revenue and the competitors, I mean to say, your product and services can be distinguished from the competitors' point of view. And these rights is securing your investment, your innovations, and your ideas so that fostering innovation and research and development is a part of the organization to invest. And by investing a little amount, you can protect your ideas, your investment, and entire, I mean to say, you can build the brand loyalty, and your market share will be very high. You can have your own identity in that way. So you see, there are different type of intellectual property rights are there, copyrights are there, trademarks are there, patents are there, geographical indications are there, plant varieties are there, industrial designs are there, semiconductor integrated circuit layout designs are there. So today we are going to discuss about patents. So you know very well uh, why patents? This is a legal instrument to protect the business assets. So when we are going to discuss about patents, we must know that how different legal instruments are there so that it will help us to understand why we need patents. Because you know, I told you copyrights. Copyrights is a kind of like you are going to protect the companies like software, code, marketing contents. So this type of things you can protect through copyrights. Trademarks are there. You are going to protect the name, the shoes logo. These are going to be protected, and we are going to protect the trade secrets. Secrecy also can be protected, like the composition, like Coca-Cola recipe. So it is going to be protected through trade secrets and industrial designs. For example, we are very much interested in developing the unique bottle shape of perfumed or soft drinks. So that also the industrial design also from the aesthetic or the ornamental aspects point of view, the shape, the configuration, pattern, color combination, that also can be protected through industrial designs. And apart from that, we have geographical indications. Geographical indications, for example, you see, when we are going to promote a product, we are going to invest something for our business, and you know very well three things when customer is going to pay customers, they are unable to get it back. One is time, money, and effort. So looking into that, we have to see the geographical indications. For example, Darjeeling tea and basmati rice. So these are the products which is very much, I mean to say, acceptable in every country, every place. So they need it because of the flavor, because of the quality, because of the originality. And looking into that, utility models are there. These are petty patents. For example, it exists for a shutter protection. It gives a shutter protection 7 to 10 years. So it is known as the incremental innovations. For example, any small innovations in tools, gadgets, or manufacturing process we are going to do, so that also can be protected. And plant, I told you, plant breeders' rights are there. We can going to protect the hybrid seeds developed by any agricultural company. So that also can be protected. And domain names is there also. For example, any name, apple.com. So digital presence, when we are going to make our business very sustainable, we would like to make it sustainable. So the domain names also plays a very important role. It can also be protected. So looking into that, what is a patent exactly? So we are going to discuss, because you see, there are two different things. Because when we are going to uh, uh, taking a grant for our idea, protection for our idea, it is valid for 20 years. So that means we have to work hard so that the business interest, business policy, business growth could be taken immediately. Because looking into that, the patent, as a patent, gives an exclusive right by the country, by the I mean to say the host country, and you are going to make it industrial application. So it may be utility patent, it may be design patent, but there must be some industrial utilization, industrial application, and that must happen very quickly. I'll be sharing one of my patent. I'll be telling you how I struggled, and I made them understand the, I mean to say, the officers about my patent. So when you are going to uh, understand about patent, you try to believe that the basic points and key points. Because as I told you, utility patents are there, design patents are there, plant patents are there. These are the three basic patents we are going to do. So when we are going to form a intellectual property that applies to the physical products or design for the physical product, is the basic idea. But what is the key things? The key things is that when we are going to assign for a certain period of time, that maybe, I mean to say, can be applied within that period, or sometime it can be also extended. So the application and the maintenance of fee, I mean to say, the maintenance could be done. So when a inventor, when a innovator is going to do something new, it allows the legal action against someone who tries to use your intellectual property. So once it will be registered, then what will happen? You will be enjoying the entire world share. You see, this is the example of a patent I have taken from the HJC company, Korean motorcycle helmet manufacturer company, holds 42 patents worldwide for its innovative helmets, and has enjoyed enormous success in export markets, where it sells about 95% of its product. And what they have done? They have reinvested only 10% of their profits, from their profits, in research and development, and attached great importance to the innovative design as a prerequisite of success in the helmet industry. And their factories are located in South Korea, China, Vietnam. It produced 1.5 million helmets in 2013, and in Korean currency, it is 80 billion. I mean to say, KRW. So looking into that, you see, the company was established in the year 1971. So they felt that I mean to say, they need uh, uh, patent protection, idea protection. So looking into that, you see, there is a difference between innovation and invention. What is the difference between invention and innovations? Let us know it. Let us discuss it. Uh, the creation of a new device, new method, new process that involves technical skill or original thinking is innovation, is invention. What is innovation? Innovation is introduction of new ideas, methods or process, especially those are more effective and efficient than the existing one, is innovation. So invention is always a technical skill or a original thinking, and innovation is a continuous process. So you can develop the process towards greater efficiency. So, looking into that, the invention and new ideas, these are the solution to the technical problems. And when we are going to start any invention, we must see that how the product, the method, or the process can be incremental improvement for a known product or the process, then only I mean to say the entire industry will be benefited. Entire system, country, nation will be uh, benefited. You see, from business point of view, these are the reasons for which we need patent inventions. So I told you there is a difference between invention and innovation. So here, why we need inventions, new ideas, new things? Because we need to prevent others from making the taking the credit through patent. So every uh, business, every entity, every commercial house, they must be looking into the new ideas every time. Innovation is required. So because we need to strengthen our market position, you know very well a product having three peripheries. One is core part, one is augmented part, one is tangible part. So there are, when we are in the market, we must be knowing which part to be given priority to patent, whether it is core part, whether it is tangible part, whether it is augmented part. So looking into that, we are going to start our innovation for increasing profit, because you know very well the product life cycle is there. A product may exist for 10 years, for 20 years, for 30 years, for 50 years, but a saturation point will come. To overcome that point, to overcome those situations, we need inventions so that the life cycle of the product could be enhanced. So to increase the profit and return on investment, we need continuous invention. And we must gain additional income from licensing. What we are doing, we can also go for giving licensing manufacturing. So you see, one is direct manufacturing, one is under license manufacturing. So we can, if at all we have got a strong inventions for our product, for our services, we can open different, I mean to say, manufacturing centers in different places, in different countries under license, and gaining access to technology through cross licensing. And we can access new markets, because expansion is the uh, only means, I mean to say, diversification of market is the key of success. We have to diversify our business. We have to diversify our market. So new market always gives us new customers. So our product demand, product consumption will be very high. So looking into that, we are going to reduce the risks of copying the invention unlawfully. If at all we have patented our product and services, our designs, our utilities, then what will happen? Nobody can copy it. And we are going to enhance the ability to raise funds, because the demand of this share will be very high. So equity could be enhanced. We can attract FDIs. And looking into that, we are going to gain a very powerful tool against imitators and free riders. Many free riders are there in this any field of the business you see. Many free riders are there. We can protect them. We can I mean to say establish our product and services in a very innovative manner, and we can boost the image of our organization, if at all we have a number of patents, then we can establish our corporate image in the market. So you see, what can be patented? Because invention is there. Because patentable subject matters. How will be the subject matters that I will be telling to you. We must have new ideas, I told you, involving very, I mean to say, capable industrial application to be incorporated, and sufficiently the idea must be disclosed. I mean to say before the patent, I mean to say application. And you see, what cannot be patented? We should not go with that because an invention is new, novel, if it does not form part of the prior art. Abstract or scientific theories, aesthetic creations, schemes, rules, methods for performing mental arts, like substances as they naturally occur in the world. Inventions, the exploitation of which may affect public order, good morals, and public health, that we cannot patent. And diagnostic, therapeutic, surgical methods of treatment for humans and animals, plants and animals other than microorganisms, computer programs, these cannot be patented. So we must bring novelty on our patent. How we will bring novelty in our patent? We have some, I mean to say, steps are there when we are going to establish our patent. So first of all, we must establish prior art. So prior art refers to all the relevant technical knowledge available to the public anywhere in this world prior to the first filing date of the relevant patent application. That is important. We must compare what was happening earlier, what is happening now. So in India, uh, in banking system, we have civil score system is there. So what we are going to do, if somebody is going to have a loan, a person will go to the bank, the civil score will be calculated. If at all it is above 700 or 750 or 800, then he or she is a good customer for the bank. But if it is below 700, the customer will feel that the paying capacity of the person is less. But this is a wrong strategy. On that, I have made one patent. So I have suggested in my patent, this should be linked to the social parameters. Civil is standing for only economic parameters. Any person who is doing crime, also he is getting the loan, and in the eye of the bank, if the person is going for repayment in time, then only that person is a gentleman in the eyes of the bank. But in the society, he is not at all a gentleman. So looking into that, in my patent, I have suggested how the social parameters could be included in the civil system. So I have prepared one framework, and I have struggled a lot to get it approved. So twice it has been in first attempt, appeal came. Then I went for first appeal. I went for second appeal. Then my patent has been accepted and approved. I got the patent certificate. So my point of view is that we have to look into the novelty point of view, how your patent will be beneficial to the society. I have established that there, if the social parameters will be included, then the crime level of the society will be reduced and the social harmony can be developed. And the persons, those are doing crimes in the society, they must be deprived of getting the business loan from the bank. So ultimately, if at all the social parameter Social parameter means a person who is very much freely donating organs. A person is freely donating bloods. A person is freely teaching in the society. A person is doing free social works in the society. So there must be some mechanism to register all those things. And that, I mean to say, the services rendering to the society, that must be calculated scientifically. And there must be some mechanism for inclusion when a person is availing or requesting for loan, business loan, or any kind of loan. The social contribution also must be coming into the screen. So looking into that, I have made it. And you see, uh, once your patent is going to be approved, it is important that a patent does not grant the owner of freedom to use the right to or the right to exploit the technology covered by the right, but but only the right of exclude others. You see, looking into that, these are the step-by-step process of registering the patent, because you must have an idea, then you go for patent search, then you have to go for build a prototype, then you have to go for file it, then test market, sell product, if at you are in the market scenario and all those things. And looking into that, I have highlighted that as there are three types of patent license agreements are there. So one is exclusive, one is sole license, one is non-exclusive license. So exclusive license, single licensee has the right to use the patent technology. And solo license is a single license, and the patent owner have the right to use the patented technology. And here, in non-exclusive license, in that case, the several licenses and the patent owners have the right to use the patent technology. In case of exclusive license, I mean to say, the person is going to use the patent technology, which cannot even be used by the patent owners. In that case, looking into the present scenario, I mean to say, India secures a position in uh, top 10 countries in patents, trademarks, and industrial designs, as per the WIPRO report 2024. India's intellectual property filing rose by 44% in last 5 years, led by 380% surge in geographical indications. So looking into that, uh, the country is doing well, and we have got our own footprints. And in conclusion, I'll be telling you that the business leverage is possible through IPR to gain a very competitive edge. Business, I mean to say, profit is, or a kind of like reputation is, whatever it may be, protecting the innovations through patents, trademarks, and copyrights, thereby preventing the competitors from the copying their products and unique brand identities. And these ideas lead to business plan. And always we must see our mission and vision, and we must see the competitors' activities. We must see the valuation and other enterprise models, and business models should be highly emerging. These are possible when the patents, products, and people will be coming together. And the legal protection is must for the investors, which is providing additional a kind of a revenue model, revenue streams through licensing or through establishing the barriers to the entry of the rivals, ultimately enhancing the business value and fostering long-term growth. So looking into that, thank you very much for your patience for listening. I am very much thankful to Eduskia Research University for giving me this opportunity to share my views in this uh, platform. So thank you very much, Professor Ruturaj Saikia. Over to you, sir.